thing over the next 6 sessions. Just a note, please remember, the sessions are not weekly. They're staggered due to various calendars. There is the second session next Wednesday, February 8th. Same time, same place. And Mr. Schmuck, please take it away. Thank you.
Hello. Hello. How's everybody doing? My name is Mark Schmuck. I am the probate research attorney here in the Costa County Superior Court. I am really thrilled to be presenting this series of law and motion seminars for probate trust and estate practitioners. As was mentioned, this is a 6-part series. I've put on here on this slide and the next slide the schedule for today. We are going to be talking about the general procedural requirements for law and motion matters. And also episode 1 will be on demurs and motions for judgment on the pleadings. Next week will be episode 2, the discovery wars, which will be on discovery motions. On February 28th, we'll be talking about miscellaneous motions in episode 3, the interlocutory orders of the Sith. We'll be talking in that episode about motions to expunge, motions to strike, motions to change venue, just a few of the random things that you might see in probate and trust litigation. Episode 4, A New Hope for Judgment, will be on summary judgment and summary adjudication. Now, before I get any angry letters, I understand that I should probably be starting with episode 4, but there's no way I'm going to be starting this series with summary judgment. That just doesn't make a whole lot of sense. So I know I'm doing it wrong, but this kind of made sense in terms of really what makes sense in terms of what order to present the episodes. Episode 5 on March 21st will be The Evidence Strikes Back regarding motions in limine. And then finally, episode 6, The Return of the Motion, we'll be talking about non-suit and post-trial motions, which will include motions to vacate, motions for a new trial, and motions to tax costs. As I mentioned, I'm the research attorney in the Contra Costa Superior Court, so I have a couple of disclaimers here. I am absolutely happy to take questions during and after the program, time permitting. If you have a question during the program, go ahead and put it in chat. I will, hopefully see them. Otherwise, I'll be interrupted so I can take the question. That's no problem at all. However, I am a quasi-judicial court employee, and I'm not only bound by the rules of professional conduct, but also by the canons of judicial ethics, which means I cannot answer questions about cases that are pending in the Contra Costa County Superior Court. And I also can't answer questions about how particular judges would rule on any issue. And so nothing in this seminar, please, nothing in this seminar should be construed as any indication of how a particular judge would rule. In fact, you're going to hear a lot in these seminars of me saying back when I was in practice. Everything that you're going to hear from me is really based on my experience in handling these motions in practice, not here while I'm the research attorney in court. And finally, all the fact patterns, examples, and sample forms, and there will be sample forms that are in this presentation are completely fiction. It's all stuff off the top of my head. Don't think that anything here is based on a real case, because it's not. You will be receiving these slides in your email along with your attendance record. And so I've included here a list of abbreviations in the that you'll see in the materials, just to kind of make things a little bit more, a little easier for you to understand. Use it with the materials. That's sort of the intent of the materials, is for you to use them after today in order to help you get through some of the issues you might run into in prosecuting any motions that you might file in the probate department. So all of these seminars are going to be dealing with a fact pattern in our law and motion universe. And so as we go through this, we're going to be dealing with the following fact pattern, at least generally. Darth Vader, formerly known as Anakin Skywalker, died during the Battle of Endor. At the time of his death, Vader was unmarried. His wife, Padme Skywalker, formerly Padme Amidala, predeceased him in childbirth. Vader was survived by twin children, Luke Skywalker and Princess Leia Solo, formerly Princess Leia Organa. Approximately 2 months after Darth Vader's death, Luke and Leia received a trustee's notification pursuant to Probate Code Section 16061.7. The trustee's notification included a copy of the Darth Vader Revocable Living Trust. The trust provides that the successor trustee following Vader's death is to be Emperor Palpatine, or if he does not survive, he didn't, then Supreme Leader Snoke is to serve as a successor trustee. Upon Vader's death, all of the assets of the trust, assumed to be worth approximately 10 million galactic credits, are to be distributed to Vader's grandson, Ben Solo, except that Luke and Leia are to each receive a bantha, if any are assets of the trust. And for those of you that don't know, this is a bantha. Shocked, Luke, but not Leia, hired an attorney to file a petition in the probate division of the Contra Costa County Superior Court, alleging, among other claims, that the trust is invalid because Darth Vader lacked the requisite mental capacity to execute the trust. Vader was unduly influenced by Emperor Palpatine, Ben Solo, and or Supreme Leader Snoke into executing the trust, and Vader was under duress when he executed the trust. And we're going to assume that Contra Costa County has personal and subject matter jurisdiction over this case, and that service of the petition was proper and timely. You're going to see this in every bit of, in all of the program materials for each of the 6 seminars. I'm not going to repeat it. I just figured it'd be fun to kind of go through it today. Again, I want to be really clear about this. The Star Wars thing here is for fun. I know that, and it really, I hope, livens up what is otherwise what I would freely admit to be a pretty dull topic, talking about law and motion of the Code of Civil Procedure. So here we go with the prologue. I'm going to talk first in the prologue about general rules that apply to virtually every law and motion matter that you're going to run into in not only in civil court, but also in the probate court. What I've quoted here is Probate Code Section 1000, which I think everybody should be very, very, very familiar with. Basically means if the probate code doesn't say it, then you look to the Code of Civil Procedure for rules on how to proceed. It seems like a pretty interesting or a pretty simple rule, but oftentimes it's not. So how do you know when the probate governs or when the Code of Civil Procedure governs? Your general rule of thumb, like I said, if the probate code is silent on the relief that you want, it's governed by the Code of Civil Procedure. And so examples that we will certainly talk about in these seminars are going to be demurs, which we'll talk about today. It's governed under CCP 430.30, and there's nothing in the probate code saying how to file a demur, or summary judgments or summary adjudication, which is under CCP section 437C. Again, there's nothing in the probate code that says how to do a motion for summary judgment. So generally speaking, for all motion matters, you have to have the following 3 elements. You'll have the notice of motion, your evidence, and points and authorities. So with regard to the notice, it's governed by Rule of Court 3.1110, which requires that the filer describe the nature of the order sought, the grounds, and the time of place of hearing, and the list of papers in support. In other words, you need to tell the court and the parties what you want, why you want it, and when you think you're going to get it. This is a due process requirement. So if you don't ask for what you're looking for in the notice with citation to authority, chances are you're not going to get it. Now, one thing that I know probate practitioners are really used to doing when they file anything is to file a probate notice of hearing. I'm a little unclear. I've always been a little unclear about whether or not when you're filing just an ordinary law in motion matter, whether or not you should file also a notice of hearing. The way I see it, it couldn't hurt. I know our court always looks for a notice of hearing, no matter what kind of hearing it is. If you got a hearing coming up, you file the notice of hearing. Whether or not it's actually required, I don't know. It certainly doesn't hurt to file it. And if it's rejected, it's rejected, that's okay. But at least you haven't created a procedural issue where one isn't necessary. So I would always recommend filing the notice of hearing. So your evidence. Evidence would include declarations, which is your most common source of evidence, requests for judicial notice, deposition transcripts, etc. The evidence always in law and motion matters must be admissible, just like it would be in trial. And your evidence must accompany the moving papers. A common exception would be a motion for a new trial or to vacate the judgment, which we're going to talk about way at the end in episode 6. Oral testimony is generally not permitted, and I'm citing here Rule of Court 3.1306. That sets out that general prohibition, but also sets out a procedure that if it is critical for the court to hear oral testimony, it gives the rules for how to make that happen. Don't count on it unless you've got a really serious, injunction issue that needs to be heard and the court needs to consider the credibility of a witness or anything like that. But generally speaking, your ordinary law and motion matter, you're not going to be able to submit oral testimony. All of that information would be submitted by declaration. Again, and so as far as declarations are concerned, they must always be under penalty of perjury and based on the declarant's personal knowledge. And that's under Evidence Code Section 702. For personal knowledge, keep in mind, generally speaking, declarations on information and belief are not admissible. Why? Because the information and belief does not demonstrate that the declarant has personal knowledge to give evidence on that particular issue. So if you're opposing a motion or a motion that has a declaration that includes the declarant's personal knowledge, you'd be pretty well off objecting to that evidence. We'll talk about objections a little bit later. For requests for judicial notice, you will want to cite to the specific subdivision of Evidence Code Section 452 that applies to your request for judicial notice. And Evidence Code Section 452 requires that you provide sufficient information to allow the court and the opposing party to answer the request. So for example, if you're seeking to judicially notice a court record, cite specifically to Evidence Code Section 452 subdivision D. Don't make your opponent or the court guess. And this is especially true when you're working on a dispositive motion where inferences and interpretations are assumed to be against the moving party. Don't create an issue where one doesn't exist. That is a very big trap and you don't want to fall into it. We're also want to mention when you're talking about deposition transcripts, when they're submitted in support or in opposition to a motion, you only include highlighted relevant excerpts that support your motion. You do not submit the entire transcript. Court's not going to read it, and it's a big waste of your time. It's also a waste of the court's time. Also, do not ever submit rough drafts of deposition transcripts. You can only include certified copies of your transcript. If you have a problem getting a certified copy, or if you need to submit a deposition transcript for a motion that's coming up and you can't get the certification, push your reporter to get it in. You've really got to work on getting certified copies of your depositions in so that the court can rely on them. That requires a request for a continuance, ask for it. Courts, in my experience, have always been pretty lenient on giving extensions of time when that kind of formality issue prevents presenting your evidence in a timely manner. Points and authorities. Motion will be denied if your points and authorities are missing. You must always accompany the notice. Exceptions to the points and authorities requirement is a motion to be relieved as counsel or a motion to appoint guardian ad litem. Both of those are based on judicial counsel forms and do not require points and authorities. The authorities here tell you what the content requirements are for points and authorities. There are page limits. For most motions, opening and opposition briefs must be no more than 15 pages. Reply brief must be no more than 10 pages. An exception to that is motion for summary judgment or summary adjudication, which are 20 and 15 pages respectively. If you're over the length maximum, if you exceed the maximum, the court has the discretion to treat those briefs as late filed, and the court may disregard them. So if you think you're going to go over the page limit, the court also has discretion to allow a longer brief upon the filing of an ex parte application for good cause. And if you're going to do that, ask for a stipulation first. It makes it easier, greases the skids a little bit. Please don't manipulate your font size in order to stay under the page limit. It is obvious, and the court will know exactly what you're doing. Either edit your brief in order to get it under length, or get an ex parte order for an over length brief. Also, if your points and authorities is over 10 pages, you must include a table of contents and table of authorities. Don't think that the court ignores the table of contents and table of authorities. The court sees it and often reviews it. So please, 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 if the rule requires it, include a table of contents and table of authorities. Certain motions have other requirements. A demur requires a document called a demur. We'll talk about that in a couple of moments. A couple of motions require what we call separate statements, specifically discovery motions and summary judgment motions. I put in here required papers include an evidentiary objection. It's not technically required, but I find that a really important tool to anybody who's opposing any kind of motion should always be considering filing evidentiary objections. It really can create havoc on the moving party if you have a well-founded evidentiary objection. A compendium of evidence is required on summary judgments or summary adjudication motions. Now, proposed orders, here in Contra Costa County under local rule 7.45, we do require proposed orders. It's a little bit awkward, only because oftentimes, even here, we will prepare our own orders. But the examiners do look for proposed orders, so you would always assume that your motion is going to be granted and submit a proposed order accordingly. However, if you're outside of county or if you're in the civil department, chances are you're not going to be required to prepare a proposed order. For this, you will certainly want to consult local practice. If you're out of county, you will want to consult the local rules. Filing and service. This is what I call the 1695 rule. Opening papers are due at least 16 court days prior to your hearing. As a practical matter, here in Contra Costa County, you won't know your hearing date until you file your papers. And almost universally, you will get a hearing date that is more than 16 court days after your filing date. So you're going to be fine. However, don't count on any court clerk from knowing how long you need in order to provide notice. Make sure that when you get your hearing date, you've provided enough notice for your opponents and for filing. Opposition is to be filed 9 court days prior to your hearing. Again, by the way, one thing I want to mention, the 1695 rule is always court days. It is not calendar days. So you want to, when you count back from your hearing date, you want to exclude holidays and weekends. So 9 court days is roughly 2 calendar weeks. And when you serve your papers, the service must be done so that it's reasonably expected to be delivered the next court day. So if you're serving by mail, FedEx it. don't do it by regular mail. You will ensure that is to be delivered by the next court day. Replies, which are always optional, are to be filed and served 5 court days prior to the hearing, 1 week, 1 calendar week before your hearing. And again, it's to be served, so it's reasonably expected to be delivered the next court day. If you file your opposition or reply late, court has discretion to consider it or disregard it. However, as I mentioned before, reply papers are always optional. Don't file them late. The court will consider them optional. If you file them late, you have a much higher chance of the court disregarding it. So make sure that if you file your reply, you file it on time. Exception to this rule, a big exception to this rule is on motion for summary judgments. That has a longer notice period, and also motion for new trial and to vacate post-trial. Those have really funky rules, and we'll talk about that in episode 6. Tentative ruling procedure, we don't use it in the probate department of the Contra Costa court. We have our probate notes that do not show substantive rulings on motions. You still get our probate notes, but just by way of background, the usual procedure is here in the slide. The court typically the day before your hearing will post a tentative ruling on the substance of the motion, and anybody who disagrees with the tentative ruling has until a particular time to notify the court and the opposing party of your intent to contest the tentative. That is usually a prerequisite to oral arguments. If you don't do it and you show up for oral argument only, you're going to get kicked out of the courtroom and you're going to lose. So that is a really important rule to comply with. The first discovery motion I ever argued outside of my normal county used the tentative ruling procedure. I didn't know about it. It was a discovery motion. I showed up for hearing. I was told, why didn't you contest? I said, well, I didn't know because I didn't know this rule. I lost the motion. It's the only time in my career I've ever been sanctioned on a discovery sanction. And it was because I didn't know this rule. So if you're out of Contra Costa County, make sure you're aware of this rule. Don't let what happened to me happen to you. If nobody contests the tentative ruling becomes the order of the court. And typically the prevailing party prepares the order pursuant to Rule of Court 3.1312. And if you contest the tentative ruling, there is oral argument. So that's the prologue. That gives you all of the rules that you need to know generally in law and motion matters. And you can see these repeated throughout the series. So now we're going to go on to episode 1, the phantom pleading. We're going to talk about demurs and motions for judgment on the pleadings. So what's the difference? Why discuss them together? And we had Jar Jar Binks with a quizzical look on his face. So the reason is it's timing. It's really, for all practical purposes, it's the only difference between a demur and motions for judgment on the pleadings. Demurs are filed before an answer or an objection is filed. Motions for judgment on the pleadings are filed after an answer or objection is filed. Otherwise, they are functionally the same motion. Now, even though there are several grounds for demurring or moving for judgment on the pleadings, what function do they generally serve? And I learned this in my first year of law school, and it's really served me well throughout my career. A demur is basically the so what defense. And that means you assume everything in the petition is true. So what? You still can't win.
I have a bad feeling about this.
That's how you feel when you get a demur. Because I got a bad feeling about this. What's wrong with my pleading? So this next slide gives you the authorities for demurs and judgments on the pleadings. Oftentimes I find that the terminology kind of gets a little bit jumbled. When you're dealing with demurs, they are either sustained or overruled. Motions for judgment on the pleadings are either granted or denied. It's very important to make sure you want the court to perceive that you know what you're talking about. And if you get the terminology correct, that's a good step in the right direction. why would you decide to file a demur or motion for judgment on the pleadings? And I've given you a list of pros and cons. And you can read this on your own in looking at the materials, but certainly from my perspective, when I was in practice, if I saw what I thought was a defective pleading, no matter how big or small the defective pleading was, I would always ask myself, if I were to file a demur or motion for judgment on the pleadings, how confident am I that I would get the entire case dismissed, even if it meant that leave to amend might be granted once or twice? If I felt really confident that I could get rid of the case early, the number one pro here on this slide, I would seriously consider advising my client to file a demur. Otherwise, it ends up being a waste of time and a waste of money, especially for your client. I mean, if you're on a contingency, maybe you might widen the scope of whether or not you would want to file a demur motion for judgment on the pleadings. But really, for me at least, if I didn't think I could win the case on a demur, I would just move on, do my discovery, and use my client's presumably limited funds to that purpose, as opposed to wasting time and money on fighting what would probably ultimately be a losing battle. So those are the things you'd want to think about in deciding whether or not to file this kind of a motion.
Or do not. There is no try.
So there you go. The grounds for filing a demur are listed here. The asterisks on this list are what we're going to talk about in more detail in this seminar. Lack of subject matter jurisdiction, lack of legal capacity to sue, abatement, defect or misjoinder of the parties we're not going to talk about, and I'll tell you why. Under regular probate practice, as everybody here should know, when you file a petition, you are ordinarily required to serve your pleadings on all interested persons. And that would mean all beneficiaries, all heirs, all conservators, all fiduciaries, trustees, beneficiaries. And in my experience, once you filed your petition, the examiners are really good at picking up on whether or not you have fulfilled your notice requirements. And so you typically don't have a problem with a defect or misjoinder of a party. Maybe you might have, a third party owner of real property under an 850 petition that you'd have to deal with. But typically you would not raise that as a demur. You would raise it as a notice issue at a hearing, and then the court can sort that out at the first hearing of your petition. But generally, you wouldn't need to file a demur raising a misjoinder of a party because of the already existing probate code notice provisions. The big one, of course, is the failure to state a cause of action upon which relief can be granted, or uncertainty. Those are the big ones that we'll talk about here today. Demur to an answer is also available under CCP section 430.20. Here are the grounds. I'm going to tell you, unless there is a really, really, really compelling reason to do so, don't demur to an answer. It's a waste of your time. My recommendation is instead to propound discovery using Form Interrogatory 15.1, which requires the responding party to provide all facts that support their defenses, including affirmative defenses. It's really difficult to, really find a way for the court to sustain a demur to an answer unless there is a massive, massive defect, or you can effectively wipe out the answer and effectively get a default in the first place. If it's an issue of, the person not having standing to object, you can certainly raise that at the initial hearing on your petition. And, if the court wants to consider argument, you could either do it by demur or, suggest to the court how the court wants to deal with that issue. But otherwise, demurring to an answer is, generally speaking, not the best idea. Grounds for motion for motion for judgment on the pleadings by a respondent under CCP section 438 C1B. Court lacks subject matter jurisdiction and the petition fails to state a cause of action upon which relief can be granted. These are the same grounds as you would see on a demur, only with fewer grounds. And the reason for that is, again, the only time that you are allowed to file a motion for judgment on the pleadings is after an answer has been filed. Once an answer has been filed, there are some affirmative defenses that are waived once the pleading is filed. And so the number of grounds that you can use on a motion for judgment on the pleadings is accordingly shortened. So really, these are the only two grounds that you can use on a motion for judgment on the pleadings. Motion for judgment on the pleadings by a petitioner can be done, again, to eliminate an answer. This is a little bit more convoluted, and the grounds would be that a petition states facts sufficient to support a cause of action. In other words, you have to prove that you have a valid claim, and the objection does not state facts sufficient to constitute a defense. Again, you're effectively demurring to an answer, which is often a waste of time. Again, I wouldn't consider doing this if you are a petitioner. So, timing. All of these motions have timing rules for a demur. They're a little bit confusing, and I hope to be able to clear up some of this confusion. The respondent's demur to a petition. The rule is that you are to file and serve not later than the initial hearing on the petition. But wait a minute. You've got a rule here at CCP section 430.40 that says a demur is to be filed within 30 days after the service of the complaint. How do you resolve that apparent conflict? Here's how. There are a couple of different reasons, a couple of different sets of authority. Number one, CCP section 430.40 that says that demurs due 30 days after service is not mandatory. And the court has discretion to consider a quote late demur so that the petitioner's, so long as the petitioner's substantial rights are not affected. As we know, objections to petitions are not due until the initial hearing on the petition. And because of that, it's hard for a petitioner to argue that their substantial rights are not affected. They wouldn't be expecting a response to the petition until the initial hearing anyway. So it'd be really hard to come up with an argument that rights are affected. The second and admittedly more highly technical argument is that under CCP section 430.10, the party against, it says that you can object by a demur, object to a pleading by a demur. Therefore, a demur is an objection. As we talked about earlier, Probate Code section 1000 says that the Code of Civil Procedure applies only where the probate code is silent. But the Probate Code says that an objector can make an objection at or before the hearing. Therefore, if you look at this, again, admittedly highly technical series of statutes, you can say that, look, I'm allowed to object and my objection is not due until the hearing, so I can demur up until the time of the hearing. Again, I'm not going to tell you that this argument has been tested anywhere. I can't give you any authority to say that this argument will work, but I've seen it. It seems reasonable to me. And then also, especially where your demur is arguing that one of your grounds of demur is failure to state a cause of action. From a practical standpoint, failure to state a cause of action is never waived. And so the respondent can always file a motion for judgment on the pleadings after you answer anyway, and the court would have to hear the same issues on that motion. So, judicial economy sort of dictates, look, if I'm going to hear it either as a demur or as a motion for judgment on the pleadings anyway, do it early. Let's hear it. Let's get these pleading issues resolved so we can move on and move to the substance and ultimately to trial. And so that's kind of how I would approach any objection claiming that a demur in a probate petition is late because of the 30-day rule in the Code of Civil Procedure. Again, for demurs, a petitioner demur to an answer. If you're so inclined to do it, again, don't do it. You file and serve the demur 10 days after service of the objection. Again, that's a short deadline. So again, I wouldn't do it. It really jams you. You're better off doing discovery. Motion for judgment on the pleadings. You may not file a motion for judgment on the pleadings until after the answer is filed, but then not later than 30 days before the initially set trial date. Note that this means that the motion must be filed at least 30 days before trial, not heard 30 days before trial. If you're going to do it that late, though, you would likely need an order shortening time for notice on your motion. Again, but here's the thing, don't wait that long. If you're working on a motion for judgment on the pleadings and you're that close to trial, by that point, because of the de novo standard of review that you would have on appeal on the granting of a motion for judgment on the pleadings, you might as well try the case to judgment, or maybe even moving for non-suited trial. You're probably pretty close to, fully prepared for trial, and it seems to me to be a waste of time and resources to argue a pleadings motion when you're about ready to go to trial. So if you're going to do it, don't wait too long. You're probably better off taking it to trial. Required documents on a demur. For the moving party, I'm giving you the list here. We'll talk about the declaration pursuant to CCP 430.41 in a moment. That's kind of a big deal. It's a fairly new requirement. The optional document is request for judicial notice. In my experience, most demurs include requests for judicial notice. Not all of them, but most do. So those are going to be required. If you don't have them, you're very likely to have your demur either continued or more likely denied or overruled. The opposing party, if you're going to oppose, points and authorities are required. Evidentiary objections are optional, but again, you should always consider raising evidentiary objections to request for judicial notice. You may even file a request for judicial notice in support of your opposition to the demur in case the court needs to consider judicially noticed facts that aren't included in your petition or in the petition. The reply, again, is all optional. You would include points and authorities or evidentiary objections to the opposition request for judicial notice. One thing that I want to talk about at this point is let's assume that a demur is filed and you are the petitioner and you think about it for a little bit. You think, oh, maybe this has a little bit of merit. I don't really want to spend time and money opposing a demur, and I'd be willing to amend. Under CCP section 472A, a petitioner, instead of opposing, may file an amended petition. And it must be filed, if you're going to do that, it must be filed up to the date that the opposition to the demur is due, which is 9 court days before the hearing. If that happens, by operation of law, the demur goes off calendar. And the respondent, after an amended petition is filed, must either answer or demur. Now, this rule applies only to demurs, not motions for judgment on the pleadings. And it only applies to a demur to the petition, to the original petition, not any subsequent amendments to the petition. And the reason for that is that petitioners always have the right to file one amended petition without leave of court before a responsive pleading is filed. After that, leave of court is always required. So this is a very limited exception that can, really, that may help, clear up any potential pleading issues. So if you're opposing, you may want to consider amending in order to, again, save some of your client's funds in order to avoid having a lengthy and slow demur process. Documents for the moving party and a motion for judgment on the pleadings are listed here. Notice of motions required, points of authorities required. Declaration under CCP 439 is required. We'll talk about that in a moment. And requests for judicial notice are optional. For motion for judgment on the pleadings, the same documents for opposing and reply papers are there as would be for a demur. So meet and confer requirement. This is under CCP sections 430.41 for a demur and section 439 for a motion for judgment on the pleadings. So back in the bad old days, when I started practice, courts had to hear demurs all the time. It was pretty rare, in fact, for a pleading to be filed, especially in civil practice, and not have a demur follow shortly after. So they were often waste of time, and when the demur was unwarranted, or when the parties could have easily stipulated to correcting the pleading defect, but they didn't. And so in 2015, the meet and confer process was established as a way to reduce the number of demurs that were filed and considered by the court by making the parties discuss whether they should resolve pleading differences informally, much like the discovery meet and confer process. It is the moving party's responsibility to initiate the meet and confer process. And so the meet and confer process does not apply where one of the parties is representing themselves as pro per. You must meet and confer in person or by phone. Right? Written meet and confer is not acceptable under this rule. The moving party must file a declaration with the demur or motion for judgment on the pleading showing a good faith attempt to meet and confer or a refusal by the other side to participate. Now, we have this rule here, but it doesn't really have any teeth because failure to meet and confer is not grounds to overrule the demur or deny the motion for judgment on the pleadings. But the court could continue, and I have seen this, the court could continue the hearing on the demur or the motion in order to parties to meet and confer. A continued refusal to meet and confer could result in a sanction pursuant to CCP section 177. Don't put yourself into that position. Even if you don't like opposing counsel or you don't want to meet and confer, you better do it. The court does have power to do things to you that you won't like. Now, this requirement to meet and confer and file a declaration, the substance of the declaration the only requirement is to report that the meet and confer happened or that the other party refused to do so. If it happened, the court doesn't need to know the details. The court just needs to know that it happened and it failed, and that the dispute wasn't resolved. Anything else is immaterial to the motion and will not likely be considered on the merits, as those are facts that are outside the scope of the petition. So again, if you did the meet and confer, everything happened, there was no agreement, it was civil, the only thing you need to do is report it. And then you've fulfilled your requirement that we can move on to the demur, or the motion. So at this time, what I'm going to do, I've prepared some sample forms that I want to show you and point out some details now that we've gone through some pretty labor-intensive stuff, and I'm going to show you some, hopefully a few Easter eggs that you all think are a little bit entertaining. And so I've got here a demur and an opposition. As you can see here, we've got Ben Solo's demur to Luke Skywalker's petition to invalidate the trust, filed by Ben Solo's lawyer. And so what I really want to point out with this sample form is each ground for demur must be set forth in a separate paragraph. And you see that in these 4 paragraphs on the demur. If you are demurring to the entire petition, you need to set that out. If you are demurring to any particular cause of action, you need to specify which cause of action. You should also, and be very clear about this, cite to the authority of CCP section 43010 that supports your demur. This is my own opinion. I know that demurs and certain judges might have their own opinions on what is required to be put in certain documents and what isn't required. I am of the opinion that if you are going to do the best job for your client possible, that there are no shortcuts. Be as detailed as possible when you're drafting any required document, your demur, any declarations, as I mentioned before, request for judicial notice, cite to the code. Always be specific. You don't want to give your opponent a reason to object to your filing. So just avoid the issue altogether. Be specific. I've got here then the notice of hearing on the demur. It's very simple on a demur. You can always refer to the demur itself for the grounds because it's a required document. You've got the date, time, location on your notice. And then you've got the documents that support your demur listed here. In a little bit, I'll show you the notice of hearing on a motion for judgment on the pleadings. It's a little bit different. Here's a request for judicial notice in support of the demur. You'll see here that you've got, number one, that the planet Tatooine orbits around twin suns under evidence code section 452G. Again, be very specific that, under 452G, that is a matter that is not subject to reasonable dispute. And so the court may be able to take judicial notice of that fact in considering the demur. 452D on number 2, it's a court record. Darth Vader's death certificate, 452C, which is a public record that is maintained by the state. Now, I've got here on a note here, which I probably shouldn't have split like this, but on a demur, there is no need to request judicial notice of the document of the petition that's under attack, because the court is already required to accept all facts alleged in the petition as true. I see it doesn't really matter if you include it in your request for judicial notice. I just want to point out that you don't need to do it to judicially notice the petition. So, and you can cite that case in support of if there is an issue. Points and authorities. I know all of you have drafted plenty of points and authorities, so I don't need to tell you what needs to be in it. Again, be detailed, be persuasive. By the end of your points and authorities, you want the court to say, well, of course you're going to win. Be succinct, make sure it's not more than the page maximum, and you'll be just fine. Here is the declaration for the meet and confer. In this particular example, I'm assuming that the meet and confer went swimmingly between Darth Maul and Cassian Andor. They've worked together in the past and they've got a pretty good professional relationship. I don't know how that's possible, but hey, that's great. Note how sparse it is. It's all you need. If you run into a situation where the meet and confer didn't happen, you report that to the court, and then the court will do what it needs to do in order to make sure that all of the rules are followed. So here we've got Luke Skywalker's opposition filed by his lawyer, Cassian Andor. And again, this is a form that can be used for either a demur or judgment on the pleadings. That's why I've got, alternate caption here for your reference. Again, this is any other pleading, any other points of authorities, no different than what you've done 1,000 times before. The next document here is Luke Skywalker's objections to the request for judicial notice. one rule when you're requesting for judicial notice in any motion at trial, anytime you're requesting that the court take judicial notice of anything, is that it be relevant. And so what I've got here is an objection to request for judicial notice number 1 in its entirety, that the planet Tatooine orbits around twin suns. Who cares? How could that possibly be relevant to a demur on a trust contest? And so your objection would be irrelevant. You want to include your statutory citation to your relevance objection. Again, no shortcuts. Make sure you have your citation. Sometimes you might need to argue it a little bit in your objection. That's okay. Just make sure that you've made your point so that the court can consider your objection and rule on it appropriately. I've also got here a sample notice of motion for judgment on the pleadings. Here, you are going to, again, list out the grounds for the demur, unlike the grounds for moving for judgment on the pleadings. You can't reference to a demur in a motion for judgment on the pleadings. It's not a separate document. So you need to list out each and every ground for moving for judgment on the pleadings. And so I've got this sample form here to show you that how that works. Let me see here. Bear with me. I'm just looking here at chat real quick. Okay, we're good. Wonderful. Let me move on. It looks like everything is in order. And we move on to the next slide. So let's look at the individual grounds. Lack of subject matter jurisdiction. This should be fairly straightforward. This is what we call a general demur. In other words, it is not waived if not raised. We are not talking about personal jurisdiction. We're talking about subject matter jurisdiction. We're also not talking about a transfer from the probate division to the civil division or vice versa. That is not a ground for demur. A transfer from the probate division to the civil division is not a jurisdictional issue. It's simply internal enforcement of local rules that govern the division of workload between superior court departments. I'm sure you may have heard the phrase that we don't really have a probate court. It's the probate division of the superior court. So if you have a problem, an issue where you think the case should be heard in civil as opposed to probate or vice versa, you bring a motion, maybe even an ex parte application. Maybe you raise the issue at the first hearing on the petition, but you do not file a demur for that kind of a transfer issue. Let the court deal with it. It is an internal issue that should not be raised on demur. An example that I'm sure you're all familiar with that would be a good ground for demurring or for filing a motion for judgment on the pleadings is a probate code section 850 claim over out-of-state real property. We all know that a California court does not have jurisdiction to adjudicate ownership of real property outside of California. And so you'd have to figure out how to deal with that in the foreign state. So if you have that kind of an issue, this would be a good way to raise a lack of subject matter jurisdiction argument in a demur. Lack of legal capacity. Again, this is a general demur and not waived if not raised. This kind of a claim is usually not apparent from the face of the petition. You want to use a request for judicial notice in order to bring the issue to the court's attention. CCP section 372, and we're talking about the examples here of minors and conservatees filing on their own behalf. CCP section 372 states that minors and conservatees lack the legal standing to sue in their individual names, and they must appear either through a guardian ad litem, a guardian for a minor, or a conservator for a conservatee. Again, this would be a very good ground for a legal capacity claim. Abatement. This is what we call special demur. It is waived if it's not raised. So if you have an abatement issue, you'll either want to demur or raise it as an affirmative defense in your answer. If you don't, it's waived. You can't bring it up later. And what abatement means is that another action is pending between the same parties on the same cause of action. And this is different from a res judicata or collateral estoppel defense. This defense assumes that another action is still pending and not that judgment has been entered with preclusive effect. So for abatement to apply, you have to prove three things. You have to file an earlier filed action is pending, means that it is currently active and has not reached judgment. That you have the absolute identity of the parties, identical parties. If you don't have identical parties, you may not raise abatement. Or you have this, and you have the same causes of action. In other words, the invasion of the same primary right. We're going to talk later about the idea that the label of a cause of action doesn't matter. It's the substance of your claim that matters. And so if you can prove all these three things in your demur or motion, then you can win on an abatement argument. This again will most likely require a request for judicial notice. Now here, if your demur is sustained or if the motion is granted, the action is stayed pending judgment on the earlier action. It does not result in any kind of dismissal. So we'll take a look and see what happens in the earlier action, and then if it affects the later filed action, then the court will take appropriate action. Uncertainty, don't do it. It is a waste of your time, in my opinion, to demur or move for judgment on the pleadings based on the uncertainty ground, but it's an available ground, so we'll talk about it briefly. They're rarely granted, and the petition has to be so bad that the respondent cannot reasonably respond. You are way, way, way better off raising this objection as an affirmative defense in your answer or objection and propounding discovery to clarify uncertain allegations. Don't expect the court to do this work for you unless the pleading is really remarkably bad. And so I've got the rules here for when the court will sustain a demur or grant the motion, and any alleged uncertainties must be specified. Okay, so now the big one, failure to state a cause of action upon which relief can be granted. Each cause of action is analyzed individually, and the label, like I said, is irrelevant. Any cause of action defeats a demur or motion, even if it's not the one intended by the petitioner. As sure you all know, it admits as true all facts alleged, but does not admit the contentions, legal contentions, or legal conclusions. So, for example, in a trust contest, will admit that the settlor had Alzheimer's disease, but it does not admit that he lacked the legal mental capacity to execute the instrument. So the demur would be sustained or the motion granted if an essential element of the cause of action is missing. For the missing element of cause of action, if you are successful in your motion, in this case, leave to amend will almost certainly be granted if the petition is missing an element of the cause of action. It's just easy to do. The court will give the petitioner every chance to make a good claim and allow the case to move forward towards trial. Problems of proof are irrelevant. Even if you think it's impossible for the petitioner to prove their case based on the facts alleged, court's going to ignore them. Again, you assume everything is true, and you can't submit any evidence to show that it's impossible for the other side to prove their case. The analysis will include exhibits attached to the petition, and hopefully when you're filing petitions in probate, you're attaching the trust, the subject trust, you're attaching the subject will, you're providing as much information as you can to the court so that in case no one objects, the court can easily grant your petition. Facts and exhibits facts that are contained in exhibits will always supersede allegations in the petition where such facts conflict. So for example, trust terms will govern over the description of the same terms in the petition, so long as they're clear. Because remember, where the terms of the instrument are ambiguous, the petitioner's interpretation will control. So for example, you have a petition for instructions on interpretation of an instrument. The petitioner's interpretation will control, assuming that the instrument is ambiguous. If the court finds that the instrument isn't ambiguous, then the instrument will control for all purposes. Another way to show that a pleading fails to state a cause of action upon which relief can be granted is to show a complete defense. A great way to show that is statute of limitations, but not all statutes will work. Under a good way to win on statute of limitations is if you can show that the petition violates CCP 366.2 or 366.3. 366.2 is a uniform one-year statute of limitations to file a claim against the decedent. 366.3 is to enforce a contract to make a will, but not one that will not work is a statute of limitations under probate code section 16061.8. The reason for that is, in order for 16061.8 to work, you have to show that the trustee's notification under section 16061.7 was served in the proper form. So unless the petition attaches that trustee's notification, you're not going to be able to get in as evidence, even under judicial notice, the trustee's notification. It's not a court it's not a court pleading, it's not a court document, it's not, subject to, it's not a fact that is unquestionably true. So that statute of limitations isn't going to work on a pleadings motion. For statutes of limitations, on or about allegations overcome a demur on statute of limitations grounds. I'm looking at my clock here, so I'm running really short of time, and I have a little bit more to go. So I'm going to try and buzz through this like the Millennium Falcon on the Kessel Run. A good way, other good ways to show a complete defense is lack of standing, which is never waived, statute of frauds, to enforce, for example, an oral contract to make a will, or res judicata or collateral estoppel. So we're now at the point where the court's going to rule on the motion or a demur.
May the force be with you.
Hopefully you're going to win. May the force be with you. These rules, I hope everybody are familiar with. Courts required to construe the petition liberally, and all inferences are to be resolved in favor of the petitioner. You have three possible outcomes. The court can overrule or deny, sustain or grant without leave to amend, or sustain or grant without leave to amend. These outcomes can apply to the entire pleading or to individual causes of action. So big issue in these motions are the standards for granting leave to amend. The court always has discretion to grant leave to amend, but leave to amend is routinely granted, especially the first time around on a petition. And I've got rules here on the slide that you can review. On the first time around, you don't need to request leave to amend if the court is inclined to grant or sustain the demur. It is an abuse of discretion to deny leave to amend where the pleading can be cured. So again, it's very likely that if the motion is successful, you're going to get leave to amend. But if the issue is strictly legal and the court rules in favor of the respondent as a matter of law, leave to amend may be denied. For example, clear statute of limitations issue, for example, CCP 366.2, that would be one way where a court would be perfectly well within its discretion to deny leave to amend if the claim is clearly barred. Don't expect, if you're the moving party, to have leave to amend denied the first time around, even if you think the issue is clear. Also, don't expect leave to amend to be denied if the issue raised is a pleading defect issue, if an element of the cause of action is missing. It seems very, very likely that leave to amend will be granted in order to give the petitioner an opportunity to cure. For the opposing party, there's no harm in asking for leave to amend, even the first time around. However, keep in mind CCP 430.41, after 3 goes, you will not be granted leave to amend unless you can show specifically how the petition can be amended to cure the defect. So now we've got the rulings. If demur is overruled as to all causes of action, litigation resumes as normal. Usually the respondent answers, and then we have deadlines here by which the answer must be filed, which
Mark,
I will
there-
leave to your reading.
Mark, there is a question in the chat and then a question in the Q&A for you.
Okay. So question, can you submit the RFAs as evidence where the trustee admits the date the 16061.7 notice was sent, and use that in the motion for judgment on the pleadings as a statute of limitations issue? It's not a filed court document, in my opinion. I will tell you that on something like that, with something that doesn't have a filed endorsement on it, you better have good authority, good solid authority in your request for judicial notice to allow the court to evaluate your specific request. I'm not aware of any specific authority. That doesn't mean that there isn't specific authority. So I know that's a really wishy-washy lawyerly way of answering your question, Nathan, but in my opinion, I don't think discovery would be judicially noticeable, especially if there are objections to the request for admission. If there are objections to your request, forget it, because those objections have to be resolved at the time that the discovery is submitted, really at trial. So hopefully that's helpful. I'm sure it isn't. Q&A question with regard to evidence presentation. What are your reviews of the court's position on electronic briefs with evidence, including videos, embedded on the actual motion or pleading? Carmen, that's a hell of a question. I don't know. It strikes me, without really having thought about it at all, that you'd have problems with authentication. You'd really have to be able to authenticate everything. So in the context of this episode where we're talking about a pleading motion, if you're outside the 4 corners of the document, forget it. You're not going to be able to have it addressed by the court. Where you are working on a motion that invites non-pleading evidence, you would need to present that evidence in the same way that you would present it at trial. And that's the general rule of thumb. Especially on a dispositive motion, like a motion for summary judgment. But I think that would be the big issue. Have you authenticated it properly? And then it becomes an evidentiary issue for the judge. So that's kind of my thought on that. Okay, so going back. Oops, let me close that. So your appellate remedy, where a demur is overruled, you have to take a writ. There's no direct appeal allowed. Appellate or writs of this nature, civil writs, are extremely rare. The last numbers that I saw were that 90 to 95% of all civil writ petitions are denied without any briefing. So you are really up against it if you think the court's wrong and you want to take a writ. A writ would only be granted really if there are jurisdictional issues, or if the petition is plainly and irrevocably defective. Where leave to amend is granted, I'm really going to start hitting things fairly quickly. The scope of amendment is really important. You may only amend the causes of actions to which the demur was sustained or the motion for judgment was granted. Unauthorized causes of action are subject to a motion to strike. So
It's a trap.
I had to get that in. It's a trap. If you over amend, you're gonna be subject to a motion to strike. So don't do it. If you need to do a further amendment, move for leave to amend. Appellate remedy where leave to amend was granted is to take a writ before amending. If you amend before taking the writ, you've waived all claims of error. Again, it's not likely you're going to have your writ granted anyways. You would really want to consider not taking the writ. If the petition is amended, the respondent can demur again and raise the same arguments as the earlier demur without violating the rules for motions for reconsideration. The reason for that is because the amended pleading supersedes the prior pleading. It's as though the prior pleading doesn't exist except for certain circumstances. If they don't amend the petition and it was a demurrage to the entire petition, the petitioner would seek dismissal with prejudice by ex parte application, and then you can have your judgment. Without leave to amend as to all causes of action, the petitioner seeks dismissal with prejudice by ex parte application, and the direct appeal lies from the judgment of dismissal, not from the order sustaining demur. You'll see a whole bunch of cases that say that filing an appeal to an order of demur is premature because you can only demur to a judgment. De novo review is done on the merits of the demur on an order sustaining demur motion for judgment on the pleadings, but abuse of discretion review is done on the denial of leave to amend. If the demur is sustained or the motion granted to less than all causes of action, the respondent would answer the remaining causes of action, and there is no direct appeal. Any questions? I'm done. That was awfully fast. I apologize if I was too fast. Are there any questions? Give you a minute if you want to ask. If you want to unmute and ask, go right on ahead. Hearing none, I'm sure that the Bar Association, oh, there's one on chat. Here we go. Really thorough crash course. Thank you. It actually helps me think about what I'm doing for future sessions. I look forward to seeing you all next week. Thank you for attending, and I'm really excited that this is a topic that interests you.
Thank you so much, Mark.
Thank you very